Welcome to our final module, Module 5. And this lecture incorporates Chapter 15, which is Juvenile Justice. Now, if I'm being completely forthright with you, this is my least favorite topic of the entire criminal justice system. And I think if you were to visit with others who work in uniform, and bring up the topic of juvenile justice, it's more likely than not that you will get an eye roll before you get a response. The reason for that is juvenile justice has undergone a ton of changes in the last 10 years that make it more restrictive for law enforcement to appropriately do their job. Now, having said all those things, those are opinions based on our perceptions and our experiences on the street. I don't want to taint your perception of the juvenile justice process because it is still a very important function that it resides within the criminal justice system. We can't operate effectively without it. From one specific profession to the other within the criminal justice system, you'll find frustrations that have a tendency to focus on the way that the different professions collaborate with each other. And it has everything to do with what their specific focus is. Law enforcement is probably the most broad of all of the professions within criminal justice, and they have a regular history of dealing with all facets of the criminal justice system, unlike some of the other ones do. And so sometimes that's where a lot of that frustration comes from. So don't read too much into my negativity related to the chapter. It's still a critical piece of our system. Specifically, we're going to talk about how the juvenile justice system was developed. We'll spend a little bit of time talking about the child savers, and we'll talk about the fact that juvenile courts were considered independent for a long time. We'll look at the big transitions in juvenile justice from 1960 moving forward. We'll talk about how police process juveniles during an investigation or when a determination's been made that arrest or detention needs to be made. We'll talk about juvenile detention and what that process looks like. And then we'll get into the courts and look at the problems associated with waivers being moving a juvenile up into the adult court system. Juvenile trials look somewhat similar to adult criminal court trials, but everything is termed completely different because of the focus of the court. And then we'll close this out with some prevention efforts. In 16th century England, the place where we have been able to trace the development of our entire system, even though it looks completely different than the British system does now. Juveniles were controlled under what's considered poor laws. So orphans or children who were considered to be delinquent was not the term used then, but that's the appropriate term for it, were managed under what's considered poor laws. And instead of placing a child within the judicial system, they were essentially handed over and placed into indentured servitude. This is a practice that came over to the Americas. It was a tradition that was carried out. Instead of letting a child run around and run wild and crazy and cause chaos, they were forced to learn a skill, learn a trade. They were also forced to do that for free until they had mastered that trade, became an adult, and could move off on their own. There were, however, systems similar to chancery courts, but those were limited to children of wealthy families, and it didn't typically deal with delinquent children at that point. It dealt with children of wealthy families whose father or mother had passed away, and they were going to be given their family's estate, but they weren't old enough to manage their affairs. So on occasion, chancery courts may deal with a wayward child, but remember in 16th century England, we're still dealing with a system that centers itself on nobility, and so that was handled very delicately. Back to the United States, the practice of forced servitude or indentured servitude was well known and put into place, and a group known as the Child Savers came to a point of political influence, and their focus was primarily to correct the misdeeds of delinquent children or wayward children. So shelters were built rather than forcing them into indentured servitude. Shelters, orphanages, etc., were built in which these children were held. However, the care in those places was substandard. One such place is considered to be a benchmark of the development of juvenile justice is the New York House of Refuge. It served as an orphanage. It served its purpose of keeping the children and delinquent juveniles off of the street, but the way that they were cared for was not appropriate. In fact, in many cases, it was just downright deplorable. However, there being no other um, method in which children could be controlled appropriately, many other states began to follow that New York model. The Children's Aid Society saw children moved from orphanages within cities and placed them in rural homes, which is almost a byproduct or a combination of orphanages and indentured servitudes. In other words, let's get these problems out of the city and let's get them out to the country where they can learn a skill and or learn a trade. Juvenile courts were not an independent function until 1899. The first juvenile court was created in Illinois. It was separate. It would be considered a limited jurisdiction court or a specialized court, but they had sole authority, sole control over all juveniles that were brought into the system, meaning they held original jurisdiction and remained completely independent of any other courts. It was a paternalistic court that encouraged juveniles to waive their constitutional rights. And the reason that they encouraged that was because the minute that they admitted their wrongdoing, the quicker the court could move towards correcting the behavior or righting the wrongs that were done. Most often, this involved being sent to a reformatory, a school, or an orphanage with a school, which was designed to reform delinquent behavior. Looking at our juvenile justice system as it has evolved in the recent past, within the 1960s and the 70s, as our text shows, the U.S. Supreme Court radically changed juvenile justice systems through several different decisions. Due process was established. Due process had always existed, but it wasn't typically followed within the juvenile process. The Supreme Court said, nope, you're not going to do that. These children are American citizens. You're going to afford them their due process rights. They also helped to develop a needs-based code, meaning graduated sanctions to a certain extent. And they created the concept of status offenses. Status offenses are only those offenses that are against the law simply because the offender is under the age of 18. Today, what we see as status offenses are minors in possession of alcohol, which would have an impact at the age of 21 and down. Minors in possession of tobacco, which is the age of 18 and down. Some cities still enforce curfews today, and so the curfew violation would also be considered a status offense. Many driving violations for restricted teens are considered status offenses simply because those violations are only in place because of the age of the offender. From 1980 to 2000, the juvenile justice system incorporated harsher penalties within that system. We began to see an influx of juvenile detention centers being built across the country. And then shortly after 2000, we began to see those same facilities begin to fold up shop and to go away. In fact, in western Kansas, there are only two places available to us to take a juvenile in the most dire circumstances, and that's Hutchinson and Garden City. And often those facilities are full, and we're stuck without a place to take a child who needs to be detained. From 2000 forward, the courts and the legislature have focused on a balanced approach that focuses primarily on changing behaviors. So they're looking at treatment, rehabilitation, and in some cases, if it's warranted, age-appropriate punishment with a predominant goal of keeping a child from entering into the detention system because there's a measurable fear that juveniles that are placed into these kind of systems are essentially entering the prison pipeline earlier than their peers. So how do police deal with this? Well, as I mentioned at the very start, this is very, very frustrating. But the balancing act that most officers have to work through is in the appropriate exercise of discretion. Police encounter about 720,000 juveniles each year. Obviously, that's going to be bigger within the big cities and occur on a regular basis. And the processes and how they handle that is going to differ based upon the agency size, how quickly they can access supporting resources through agencies like the Juvenile Justice Authority, and whatever the local court procedures may be. Um, this makes discretion critical. So if in Northwest Kansas I have great difficulty in accessing JJA or determining where a juvenile needs to be placed or asking them to do that for me, and they're encumbered by a large number of cases that exist in larger cities such as Salina, Wichita, or Topeka, I'm going to be stuck waiting, which means most likely my decision making process is going to involve only detaining a juvenile if I absolutely have to. Diversion systems, especially for status offenses, are heavily used, especially for first time offenders. Kids explore stuff, kids get into stuff. Each of you can probably remember the first time you tried something you shouldn't have. Um, this is a normal process of growing up. Doesn't make it right, it just makes it a normal behavior or a common behavior. And so kids who are given tickets for MIP are often diverted, in which they have to pay a fine, sometimes attend a class, maybe even a little bit of supervised probation for a while. And those will all vary based upon the region and the system that's in place. There is a set of new federal rules that the Department of Justice is handing down that greatly restricts how it is that officers handle juveniles once they've taken them into custody. And it deals more with the physical structure of buildings. Juveniles cannot be placed in locked rooms um, by themselves. They cannot be processed in a facility that holds adults if that processing center is anywhere within sight or sound of adult inmates. They must be completely separated. And jails are inspected on a regular basis to make sure that those things are being complied with. Juvenile detention has always been controversial. There has always been public discord related to whether teens should be placed into jail or not. And those conversations will vary based upon the case that has brought that conversation up. In any case, though, when a juvenile is being detained, there is an emergency hearing. And I call it an emergency hearing because it happens within 48 hours. But a magistrate judge is required to consider the affidavit of fact related to the case or the decisions that the officer made related to placing that juvenile into custody and to determine if detention is still appropriate or not. Again, access to facilities that are capable of detaining a juvenile and continuing their education is difficult, which is a significant factor for the judge to consider. And in most cases, if a juvenile needs to be detained, they're not taken to a facility. They're placed on house arrest and electronic monitoring, meaning they're stuck at home with a GPS bracelet around their ankle. The decision for placement does not reside with law enforcement officers. We can make a decision that an arrest is warranted, but it's a combination of the prosecutor and the judge and the Juvenile Justice Authority about whether or not that juvenile should be placed within a detention center or be placed on house arrest. Our job is simply to explain and describe in great detail what occurred and explain our arrest or not arrest decisions, and then let the system make its decision from there. Today, in a practical manner, we typically only see violent offenders detained, meaning if they've committed a person felony, they're going to be placed into a juvenile detention center. But any crime lesser, they're most likely not going to be unless they absolutely refuse to abide by the court's rules and obligations. As with any facet of the criminal justice system, there are regular challenges made to the state Supreme Court or the United States Supreme Court related to how we handle juveniles. And some of the problems that exist relate to when it's appropriate to hold an offender within the juvenile system and when they should be passed up to the adult court system. And that process is called waiving a juvenile into the adult criminal courts. The manners in which that can happen is by direct filing. In other words, if the prosecutor's examined a case and has made the decision early that they're going to seek to try a juvenile as an adult, they can make that notification at the exact same time that they're filing the case, and it's almost always immediately heard at the adult criminal court level. Now, a judge has an opportunity to reverse that and send it back down to the juvenile system, but it will depend upon the offense and what the weight of the evidence looks like. There are offenses within the juvenile code that prevents juvenile courts from asserting jurisdiction, meaning if a 15-year-old committed a homicide, um, it would be considered an excluded offense in which a juvenile judge could not assert their jurisdiction over that child. It would automatically be placed into the adult court system. Those are extremely rare cases, and they are almost always extremely horrific crimes that have occurred when that occurs. There's also the concept of blended sentencing, and this is relatively a new practical development for law enforcement, at least out in western Kansas, in that depending upon the weight of the crime, we have seen juvenile offenders who have been sentenced formally into the juvenile justice system, but hold an underlying adult sentence. I've experienced two of these cases within the last 6 years, and essentially the outcomes of those cases were that those juveniles were sentenced to spend their time at the state juvenile justice facility in Topeka until they were 21 and a half years old. The hang up with that case, or the extra burden on those juveniles placed in there, was that they were also sentenced to 10 years in the Department of Corrections. So the juveniles were led to understand that they could spend from the age of 17 until they were 21 and a half in the juvenile system. They could abide by the rules, they could obtain their education, they could work on reentry into the community, or if they failed and caused problems and had disciplinary issues within the juvenile system, they would be removed from there and transferred directly to a prison within the Department of Corrections to serve out the remainder of their sentence. In the two cases that I've experienced, it has held pretty significant leverage against those offenders to ensure that they're abiding by what they need to. One successfully completed his juvenile sentence and his prison sentence was set aside, and the other one is still currently completing his juvenile sentence. In court, because juvenile courts are different, they have also applied different labels, different titles to the functions within the court, but they look very similar to what it is that it occurs within an adult criminal system. Trials in the juvenile system are known as adjudication hearings instead of simply a trial. An initial appearance takes place instead of a first appearance or an arraignment, but the procedure is very similar. The offender and their parents are informed of the specific charges, what the potential penalties look like, and the judge takes time to ensure that both the juvenile and the parents understand what constitutional rights are present. And in most cases, at a practical level, the judge will work to make sure that that juvenile is represented by counsel, whether it's forcing the parents to hire an attorney or appointing one and requiring the parents to pay that cost. There's very little in any high-level misdemeanor or even low-level felony cases in which a judge hearing a juvenile case is willing to move forward without that juvenile being represented. Most cases end at the initial appearance stage. There are very few times that an adjudication hearing where all of the evidence is presented actually moves forward. In most cases, those hearings end at the initial appearance in which an agreement related to treatment has been laid out that's in the best interest of the juvenile. The prosecutor, the defense attorney, and the judge all must come to an agreement on what that looks like. Typically, it's already a pre-made program that JJ has and is willing to put that juvenile into that system. Disposition is a legal term for juvenile sentencing. That's all that it is. That's when the court hands down its order for what that juvenile is going to be required to do. And then treatment instead of corrections is just the change in labeling at that point, because again, the goal is to intervene in the child's life prior to adulthood to end criminality within that youth, or in the desire to act in a criminal manner within that youth. It is a function of the Department of Corrections. JJA in Kansas answers to the Department of Corrections, and so it's all under the same roof, just all has different labels because we're talking about juveniles and not adults. So what can communities do to reduce the traffic into the juvenile justice system or to keep kids out of juvenile court? Well, That's difficult, simply because juveniles typically are restless, and depending upon what their life at home is like, will also have an impact on how productive they're going to be as high school students, etc. It often requires direct intervention. To prevent someone from acting in a wayward manner requires a direct intercession by someone, not always law enforcement, sometimes a respected community leader or someone who's close within that child's life that will step in at the appropriate time to keep them from going down the wrong path. However, most communities have some kind of delinquency prevention program in place, even if it's informally framed in that manner. Those are going to be things like community youth centers, the YMCA, the Boys and Girls Clubs, and Job Corps, any of those kind of programs that exist out there that are designed to occupy a juvenile's time and to keep them busy instead of idle, in which the circumstances arise where they may act in a delinquent manner. That is juvenile justice at a high level. Now, I do want to talk a little bit about this week, because last week I asked you to read 2 chapters and write a discussion post and take a quiz. And this week I'm asking you to do the exact same thing again. Module 5 is very short. It only incorporates 2 chapters, and it just simply closes our course out. But what I'm attempting to do is to give you the free space and the capacity to focus on your final paper. Within Chapter 15 are some U.S. Supreme Court cases that you may want to take some time and review on your own, and they may become your research topic for your final paper. Remember, I'm asking you to consider a United States Supreme Court case that has been influential on the entire criminal justice system. And so you've got a pretty wide area to research within there. And so if you have a specific interest in juvenile justice, I would encourage you to consider some of these Supreme Court cases listed here in Chapter 15 as potentially one of your topics for the paper. Anyhow, we've got one more chapter to go, a discussion and a quiz to get through. Please make sure, as always, that you're marking your attendance on Mondays as is necessary. And as we get closer to the end of this course, I just encourage you to remain strong, stay focused on completing the goal, which is successfully completing this class.